Today on Diagnosing Health Care, we're going to be discussing the prognosis for criminal healthcare fraud enforcement in the second Trump administration. Hello and welcome. I'm your host, Richard Westling, and I'm an attorney in Epstein Becker Green's Healthcare and Life Sciences practice in the Washington, D.C. office. We're recording on March 21st, 2025, and U.S. Attorney General Pam Bondi has been on the job for about 6 weeks. From day one, we saw significant shifts in the department's criminal enforcement priorities. Today, we'll discuss our expectations about criminal healthcare fraud enforcement under Attorney General Bondi's leadership and how that may impact the healthcare industry. If what you hear today is helpful, please subscribe to the show, Diagnosing Healthcare, which is available wherever you get your podcasts. I'd like to start by introducing the guest that I have with me today. Joining our discussion today is Sarah Hall, a member of the firm in our Washington, D.C. office. Sarah is a former DOJ fraud section prosecutor, and we'll have a lot to add about her experiences at Main Justice. Sarah, welcome.
Good morning, Rich. Glad to be here with you. Thanks for having me. Rich, just to add a little bit of introduction about myself, I started out as a healthcare fraud prosecutor with the strike force in Main Justice, and so I have a lot of experience on the prosecution side as well as on the defense side in the realm of criminal healthcare fraud. So happy to be part of this podcast today.
Well, it's great to have you. Also joining us today is Melissa Jampol, a member of the firm and a member of our board of directors here at EBG, who is in our New York office. Melissa is also a former prosecutor, both a federal prosecutor in the U.S. Attorney's Office in the District of New Jersey and an assistant district attorney in the Manhattan DA's office. Good morning, Melissa. How are you today?
Hi, thanks for having me.
And then finally, we have joining us Tom Jaworski, a member of the firm in our Nashville and Washington, D.C. offices. Tom is the former acting United States attorney in the Nashville U.S. Attorney's Office. Great to have you, Tom. Good morning.
Hi, Rich. Thanks for having me. I'm looking forward to speaking on today's topic. And I think I have a lot to add as I served in leadership in the first Trump administration and also in the prior administration that just left office. So I'm looking forward to speaking with everyone today.
Well, great. It's great for you to have the time with us. So I want to start by talking about some structural issues that may impact healthcare fraud enforcement in this new administration. Tom, you were recently the acting United States attorney in Nashville, and I'm wondering if you can tell us what role the United States Attorney's offices play in healthcare fraud prosecutions and how you expect DOJ's changing priorities to impact that role.
Sure. Thank you, Rich. The U.S. Attorney's Office is situated in the 93 federal districts, are really the ground zero where a lot of these cases start. That's because these are the offices that are closest to the community where alleged fraud, waste, and abuse may be occurring in healthcare. The local offices also have the agent relationships with people at the Federal Bureau of Investigation, at Health and Human Services, at the DEA, and various state agencies throughout the country. So in terms of healthcare, there are already a lot of cases in the pipeline. In 2023, the last year for which we have statistics, there were about 800 criminal investigations opened, which are still ongoing. Our listeners may know there was a major enforcement action last summer involving about 400 defendants in about 36 districts. So those cases are still pending as well. In terms of priorities, I think what you could see in this administration is a bit of reshuffling. There may be a bit less in terms of tax prosecutions, public corruption prosecutions, and foreign corrupt practices actions. But healthcare should be here to stay simply because of all the cases in the pipeline already. And because I think one thing both parties can agree on and everyone can agree on is that fraud is bad. And any way that we can we being our government can work to ferret it out and investigate and prosecute it is a good thing for the taxpayers, especially in this age of where the federal government is trying to be more prudent with its spending. You can look at a lot of statistics, but it seems readily apparent that the money invested in investigating and prosecuting healthcare fraud brings results. For every dollar invested, the government claims that they saved $3 in terms of what's actually recovered on the back end. And there's also the deterrent effect that every dollar spent on enforcing healthcare fraud deters between $10 and $20 in terms of fraudsters out there.
Melissa, as a former assistant U.S. attorney, I know you're familiar with the role that the FBI and the OIG agents play in criminal healthcare fraud enforcement. We also know from reading the headlines today that the FBI is being focused on as a subject of reform and that the IG, the Inspector General at HHS, has been removed. I'm wondering if you can give us a sense of what impact you think these changes in investigative agencies may have on healthcare fraud enforcement in this administration.
Thanks, Rich. Well, I certainly agree with Tom's analysis that healthcare fraud investigations are here to stay. I think with the huge central role of healthcare, Medicare, Medicaid to the overall federal budget, as well as the aging of the baby boomer population, as well as, real pockets that DOJ has been trying to root out fraud in for years, that healthcare is an area that is likely to be a continued target of the Department of Justice, no matter who's in charge over there. I do think that the role within the investigative agencies is likely to slow things down a bit. We do believe that there's plenty of cases in the pipeline that are still being investigated. But when you have uncertainty at the top, when you have uncertainty in leadership positions, when you have uncertainty in decision making, when you have folks turning over in terms of who's in charge, I think that definitely has a tendency to slow some things down. There's so many rumors at this point about what's going on over at HHS OIG and people trying to leave, agents being pulled in different directions who are working on cases. And we certainly know that over at the FBI, there have been plenty of changes and, sort of overall morale issues, not only at the law enforcement partner side, but also within the U.S. attorney's offices. So I think that overall, we're likely to see continued enforcement. I just think that sometimes things may slow down. But I do want to really caution that we're used to things slowing down in this venue. Anytime there's a change in administration, we see a bit of a slowing down. And those of us who defend companies who are under investigation and defend individuals under investigation, believe it or not, 5 years since COVID started, still dealing with the effects on the judicial system of things really slowing down from COVID. So I want to say that some of this is not new, although the sort of way it's been packaged of the uncertainty is certainly new to all of us involved.
Understood. And Sarah, I want to turn to you now because, as you noted, you were a fraud section prosecutor at the Maine Department of Justice in Washington, where you were a member of a healthcare strike force. And we know they do a lot of work in the criminal enforcement space. I'm curious as to what you think the strike forces and the fraud section's role will be going forward. Do you think it'll change in this administration when it comes to healthcare?
To answer your question, I think it would be helpful just to sort of paint the overall picture nationwide for enforcement from the prosecutor perspective. Um, the U.S. attorneys' offices around the country, they all have their own healthcare fraud coordinator at a minimum, and depending on the U.S. attorney's office, will investigate and prosecute healthcare fraud cases on their own. Maine Justice, where I was a prosecutor in the fraud section, has one of its litigating units, the healthcare fraud unit. And that is a dedicated unit that operates nationwide in pretty much every jurisdiction in the United States, exclusively focusing on the investigation and prosecution of healthcare fraud and related financial crimes such as money laundering, structuring, things of that nature. And so currently, the healthcare fraud unit within the fraud section has about 80 or so dedicated healthcare fraud prosecutors. It's all they do. Unlike assistant United States attorneys in the various U.S. attorneys' offices around the country that tend to have diverse dockets doing all sorts of different criminal enforcement cases, the trial attorneys in the healthcare fraud unit in the fraud section only do healthcare fraud cases. And so they partner with the U.S. attorneys' offices in various jurisdictions to typically work together to bring these cases, to investigate and try these cases. I don't think it's going to change too much. It's been a longstanding program to have these dedicated healthcare fraud prosecutors out of the fraud section. It's a very well-established program, and as Tom referenced, brings back a lot of money to the U.S. Treasury in terms of recoveries. There's a long history of working cooperatively and collaboratively with the U.S. attorneys' offices. Um, and the healthcare fraud unit trial attorneys are specialists. They, like I said, they do these cases day in, day out. They don't do other types of cases. They're basically expert prosecutors in this area. I agree with Tom and Melissa that healthcare fraud is sort of a nonpartisan issue. Pretty much no matter which party is in the White House, which party is controlling Congress, there typically is always an appetite for continued investigation and prosecution of healthcare fraud. It doesn't typically, sway with the winds of political change. It's not perceived as a terribly controversial area of prosecution. And to echo what Tom said, because it does bring back so much money to the federal coffers, especially when you combine that with civil healthcare fraud enforcement on the False Claims Act side, which brings back more than on the criminal side. It's viewed by the powers that be within the U.S. government, no matter what party is controlling the White House and Congress, to be a good government program, a good use of federal government resources. And so I don't necessarily see anything changing in that area. Time will tell, but I believe that the comments that have been made so far by, for example, Attorney General Bondi and others tend to support the view that healthcare fraud enforcement, criminal as well as civil, will most likely continue along the lines of the status quo that we've seen over the past administration.
So it sounds like as a group, I think our general view is that we don't expect there to be a move away from healthcare fraud enforcement, and that because of issues that the panel's already talked about regarding the focus on waste and abuse, the concerns about return on investment from enforcement, and the fact that it's a very productive program, and the fact there's also dedicated funding for personnel, all suggest that we're going to see at least something that's reminiscent of the past in terms of enforcement. So I want to turn our attention now to the focus areas of enforcement. So we've talked about the fact that we think there will be enforcement. The question is sort of, where do we expect that enforcement to be aimed? And obviously we all know, doing this on an everyday basis, that the anti-kickback statute is sort of the go-to statute for healthcare fraud enforcement in the criminal space. Tom, do you expect that to continue to be sort of where prosecutors sort of aim in terms of the kind of conduct they're looking at?
I do, Rich, because the anti-kickback statute is a very easy concept for jurors to understand. And it's really the bread and butter of the healthcare fraud prosecutors, at least in the 93 federal districts. Statute clearly makes it illegal for a medical practitioner to pay or receive anything of value in exchange for a referral, where that referral results in a payment being submitted to the federal government in either Medicare, Medicaid, or TRICARE, which is insurance for our veterans. So yes, I certainly expect that to keep going. There's a track record of success in those cases, and I don't expect anything different in the foreseeable future.
So the other area we've seen a lot of activity in over the last few years has been related to sort of opioid abuse and the role that medical practitioners sometimes play in those cases. Sarah, I'm curious as to whether you expect that trend to continue in the new administration. Should we expect to continue to see these kinds of opioid prosecutions being brought by the fraud section in the U.S. Attorney's offices?
Rich, I think that's a reasonable expectation to have. One of the data points that I would look at to try to answer this question is the background of our new Attorney General, Pam Bondi. I mean, she was the Florida AG for 2 terms and spent more than 18 years as a prosecutor in the state of Florida. Florida in DOJ circles has traditionally been known as especially South Florida, the epicenter of healthcare fraud in the United States. So healthcare fraud is not a new concept to our new Attorney General. She has a lot of experience in the area of prosecuting pill mills, and if you look at her official bio on the DOJ website, many paragraphs of her official bio were dedicated to talking about her work prosecuting healthcare fraud as the Attorney General in the state of Florida. She specifically focuses on talking about oxycodone dispensaries in the state of Florida and the actions she took to prosecute those illegal operations, as well as changing state law in the state of Florida to to deal with basically pill mills and related clinics. She also served on various nationwide committees in regards to opioids and drug abuse prevention when she was AG of Florida. And so my expectation would be that, informed by her prior prosecutorial experience in the state of Florida, the continuation of prosecuting what are referred to as pill mills will continue.
Yep. Thank you for that. And Melissa, I wanted to get your thoughts on other areas of focus for enforcement. I know we've seen activity with PPP fraud, the protection, COVID related issues. I know we've seen areas related to genetic testing. Do we expect that kind of stuff to continue? And if so, are those the only areas, or do you think there are other things that are coming on the radar?
Thanks, Rich. This is actually one of my favorite topics, is peering into the crystal ball to determine what next a creative prosecutor will decide to investigate. So I'm glad we're discussing that topic here today. Definitely PPP fraud, that ties right into the focus on combating fraud, waste, and abuse that we've seen the current administration um, enthusiastically embraced from their first second taking over. I think we're going to see other frauds from the COVID pandemic era, such as lab testing issues. We've seen a bunch of those cases percolating their way through the system. The last, I'd say, about 8 years, we've seen a preponderance of genetic testing and DME cases, both civilly and criminally. And I think that those are still yielding cooperators who are giving information on other folks investigating. My old district in New Jersey had a big conviction last week involving one of the major prescription drug compounding cases that had been pending for forever because it had been delayed repeatedly during COVID. To answer your second question, Rich, at the ABA White Collar Conference, there was some talk about wound care fraud cases still continuing and that being an issue. And I think everyone's in agreement that sort of the next frontier is the use of artificial intelligence and electronic health record cases. While I have the chance, I will say I agree with Sarah that opioids, although we got some good news this week that opioid deaths are down nationwide, which was amazing to see. I still think that the current administration, and knowing who the DEA administrator is going to focus on opioid cases. And I think tied into concerns about increase in healthcare costs, you could see some investigations involving pharmacy benefit managers, PBMs, as well.
So, Tom, I know that under the last administration, there was a whistleblower program started in the criminal side of the House, which is not something we see routinely. We're used to whistleblowers more on the civil enforcement space. And I'm wondering if you have a sense of whether you think that's going to continue in this administration, and if so, what its impact may be.
Sure, Rich. It's tough to say, but I would think that it would continue. For the first time, the government is opening its doors and telling people, come in and tell us about fraud that you see in private insurers, which is a whole new, in the government's view, an untapped universe of areas that they can pursue. Typically, the fraud the government prosecuted would be fraud involving the federal programs, Medicare, Medicaid, and TRICARE. This is an expanded universe in which I would think it would make sense that the new administration would keep that going. Too early to tell at this point.
I think you make a really good point, Tom, that is important for our audience to understand. And that is, unlike the civil enforcement arena where the federal government is involved, which is almost entirely focused on federally funded programs, the healthcare fraud statutes, at least the proper healthcare fraud statutes compared to the kickback statute, actually applies to any, quote, federal health program. And that is actually defined by the code as really any program that is providing health insurance. And so what we see on the criminal side that we don't often on the civil side is cases that can be entirely based on defrauding private health insurers. And Melissa, I know you've probably had experience in cases that involve that element. in your role in the District of New Jersey and probably as defense lawyer as well. But I'm curious whether you think this whistleblower program is likely to be helpful in ferreting out more of those kinds of cases.
So, Rich, I do think that it will be helpful for the government and maybe not so helpful for our clients or causing them a lot of drama in the interim to get through these cases because the volume of money that's also in the private health insurers is tremendous. So, we've been talking a lot up to this point about Medicare, Medicaid, TRICARE, federal employee health benefits programs, things like that. But there's a whole other area of health insurance that has to do with private insurance. And those cases involve, to bring to fruition from the prosecutor's point of view, a close collaboration between the private health insurance companies and the U.S. Attorney's Office, FBI, OIG working together to work through those cases as well. So I think that we've seen over the last few years much more coordination between private health insurance companies and the federal family of alphabet soup of agents and the prosecutor's offices, and that is likely to continue. One other area that I think is worth mentioning as well, Rich, is that we're likely to see some of this healthcare fraud enforcement being pushed down to the state level as well, with states increasingly getting involved in just pure state claims, pure state False Claims Act cases. And we're working on some of those right now in terms of some of the defense that we're doing, which is just really limited to just state claims involving allegations of fraud involving Medicaid programs.
That's a great point, Melissa. And Sarah, I guess I'm interested in your thoughts around that. I know at the fraud section you all handled a lot of federalized cases that dealt with Medicare and Medicaid. Did those cases also involve private insurance? And I guess to the extent you did Medicaid cases, was there generally a lot of coordination with the state Medicaid fraud control units?
Yeah, Rich, we did have, when I was at the fraud section as a prosecutor, we did regularly coordinate with the MFUCUs, the Medicaid fraud control units of the states that we were bringing our cases in. Medicaid is, it's a joint program funded by federal money as well as state dollars. Um, every state is required to have a MFUCU, a Medicaid fraud control unit, and they can be, they're typically a partner in not every case, but a lot of cases, especially when you have Medicaid, when you have a high volume of Medicaid claims at issue in your given case. As far as whether I saw a lot of private insurance cases being brought, not a lot, because and the reason I believe for that is that most private health insurers have had for a lengthy period of time their own highly effective special investigation units. They have different insurance companies will call them different things, but essentially an investigation unit that is devoted to preventing false claims upon that particular private insurance company. And so you don't often see the private insurance companies in sort of the routine healthcare fraud criminal cases as much. It's usually, and the Department of Justice, obviously, they want to protect federal money. That's typically the priority. So when the claims that are at issue are being paid by Medicare, Medicaid, TRICARE, Jampol, all the other federal programs, that's typically the priority of the federal enforcement system. And the private insurers, while you're absolutely correct, they do technically qualify under the U.S. Code in terms of the criminal statutes, in terms of what can be prosecuted as a criminal healthcare matter. But you see them less. They typically take care of their own claims privately and don't typically rely on the feds as much to vindicate their interests.
So the other thing I think we are seeing in this administration, at least arguably, is a move away from a focus on sort of what I would call corporate prosecutions. At least some changes that have gone on in the policies around the Foreign Corrupt Practices Act, which tends to be often something that is aimed at corporate behavior, definitely seems to be a brave new world in this DOJ. But I'm curious about whether we see a similar trend that is likely to occur when it comes to corporate investigations for healthcare fraud crimes. And Tom, I guess I'm interested in your thoughts. I know you have a sense, having run a U.S. Attorney's Office, about the deployment of resources and how that affects things. I'm just curious about, do we think that we're going to continue to see corporate cases, knowing that traditionally criminal cases are overwhelmingly about individuals, but we have seen them over the last 4 years and before that? What do you think is going to happen there?
I think it's unlikely you'll see a lot of those at the US attorney level for a couple reasons. One being that resources are already stretched thin. Last year was a difficult year budgetary wise, hiring freeze now. While there's always turnover in a new administration, there's been a little bit more than usual for whatever reason in this administration. So definitely short on bodies over there to do that work. And the corporate investigations can be extremely time sensitive. You have sophisticated counsel. They don't happen immediately. The resources right now are, as we've discussed, being directed towards immigration and violent crime. And that's going to be the priority of this administration and probably any United States attorneys that are appointed in this administration. So you'll still have healthcare prosecutions, I believe, but I don't see them going the corporate route in most instances, at least in U.S. attorneys' offices, for those reasons.
I think that makes sense. And I'm curious, Sarah, when it comes to what we've seen the department do in resolving corporate investigations that are criminal in nature, over the years, we've seen a number of deferred prosecution or non prosecution agreements. Do you have any sense at this point what the new administration's view may be about those kinds of resolutions, or whether they may just not be that important if we're not actually going after corporate offenders?
Yeah, that's a great question, Rich. Without getting too far over the skis, as they say, since we're just early days in this new administration, I think what I can say with a degree of certainty is obviously, as you referenced, the new administration has put a pause, perhaps temporary, perhaps permanent, on the investigation and prosecution of the Foreign Corrupt Practices Act, or the FCPA. The FCPA unit is one of the litigating units in the fraud section, where I was a prosecutor for many years. It is a small unit. It's perhaps only 30 or so prosecutors, but what they lacked in size was made up for in many, many, many big, sophisticated corporate prosecutions for FCPA violations. And where you see a lot of use of deferred prosecutions or DPAs, non-prosecution agreements or NPAs, is in that FCPA space. Obviously, the U.S. attorneys' offices around the country do use DPAs and NPAs, differing volume levels depending on which U.S. attorney's office you're talking about. But I think just in sheer numbers overall, because we will see a decrease in FCPA work, or perhaps a complete cessation of FCPA work in this administration. I think just statistically, numerically, we're going to see a decrease in the use of DPAs and NPAs. And whether that carries over to a broader national trend of not investigating and prosecuting companies as a whole, I think we're just going to have to wait and see. It depends on the company, right? I mean, some companies are huge and some companies are small, and they all have different considerations when it comes to enforcement priorities. But I think this is perhaps a topic that we're still early days, and we may have to wait and see what the new administration does.
I think that all makes sense. I think we're all scratching our heads a little bit about where some of this stuff may go. Melissa, I wanted to talk with you a little bit about what we've seen over the last administrations in terms of pronouncements around individual liability, the idea that people who are involved in conduct should not sort of be allowed to slide in cases where there's a corporate investigation. And I'm curious as to whether you think anything that we've seen from the administration thus far gives us any insight as to whether they're going to continue that approach, or whether there'll be some backing off of it in light of changing priorities.
So, Rich, I've taken out my globe here to try to see the future about what's going on. But I think that this is an area that we really haven't heard much about from the government. It's certainly not in the healthcare context. I think we can look for clues in, the political corruption side of the world, where we've seen cases being dismissed against very high profile political corruption targets, such as Mayor Adams here in New York, and other places like down by down by Tom. There was a big case that was dismissed, a big investigation. So I think that we've seen some very high profile folks get their cases dismissed individually. But in terms of for the common Joe who's being investigated for healthcare fraud, or common Joe doctor or nurse or something like that, we really don't know what the administration is gonna go. I think that this concept that has been out there that companies don't act alone and that it takes individuals behind them is really what propelled the momentum that we saw in the wake of the financial collapse and the recession, and a lot of impact and feeling that, well, while we had a big financial collapse, that there weren't individuals who were held accountable. That has sort of played itself out over the last few years, last couple of administrations. And we really don't see a sense at this point what direction this administration is going to go in. I'm curious if Sarah or Tom have any thoughts on that. And maybe they've seen some other stuff I haven't.
So, Melissa, what I would say is that the concept that we commonly refer to as the Yates memo, which was a DOJ internal guidance memo authored by Sally Yates in a prior administration, which instructed federal prosecutors to prioritize the prosecution of individuals as opposed to companies. I think that concept in general will continue no matter what administration we're in, simply because DOJ institutionally believes that the best way to effectuate deterrence of crime and punishment and things of that nature is to go after individuals. Going after companies in the criminal context, you can't put a company in prison. All they can do is pay a fine and perhaps be on corporate probation. But the traditional DOJ view is that prosecuting companies does not achieve the same deterrent effect as prosecuting individuals. I don't think that's really going to change. I think that will continue forever. It's sort of the flip on the civil side, where the priorities are perhaps different. For example, the False Claims Act, the remedy of the Department of Justice is it's a money judgment. The priority on the civil side, on the False Claims Act side, is companies, because companies typically can pay the fine associated with the False Claims Act case. So it's a totally different calculus. But if we're limited here in our podcast to criminal enforcement of healthcare fraud statutes, I believe that the principle of prosecuting individuals, shorthand we would call it the Yates memo, is going to continue. Tom, what are your thoughts?
Yeah, I think you hit the nail on the head there, Sarah. As someone who's been on that side of things, the result after prosecuting a company can be wholly unsatisfying in the end from the government's perspective. And so that, combined with the fact that these resources are so limited right now, that they're going to have to focus on targeted areas. And when I was in the office, in a prior life, wanted to prosecute everything, but that's just not realistic. And it's even more unrealistic today.
So, look, we've talked at this point for a little while here about our prognostications, about what's going to be coming. We've done our best to, I think, read the tea leaves that are in front of us to give a sense of how we think things will remain the same and how they may be different. But I'd like to ask each of you now just to kind of sum up here with a comment about how we see this new administration and its healthcare criminal enforcement affecting the healthcare industry. And I want to start with you, Sarah.
Rich, what I would say is that, even though our podcast here is really focused on criminal healthcare enforcement, for healthcare companies operating in the United States, your view really can't be that narrow. There are many, many other remedies that are available to the federal government that pose a lot of risk to healthcare companies, whether that's the False Claims Act, which is a huge area of risk, discretionary enforcement actions from CMS or HHS-OIG, payment suspensions, things of that nature. So you have to look at the concept of criminal healthcare fraud enforcement in this broader context of business risk to companies and individuals in the United States. And I think that if the investigation at hand or the facts that are under investigation by the government rises to the level of getting kicked over to the criminal side of the house, whether that's in the U.S. attorney's offices around the country, whether that's in the fraud section where I used to work. That's obviously the worst case scenario for a company or for individuals. But it doesn't happen as often as what we see in perhaps the False Claims Act setting, where key TAM relators, whistleblowers are very active. The plaintiff's bar in that sphere is extremely motivated by large payouts of money under the False Claims Act. And so you have to look at it in this broader context of risk assessment. But I think big picture, I don't think healthcare fraud enforcement, whether that's investigation, prosecution, or all of the above, is going anywhere anytime soon. As I believe Melissa alluded to, we've got the aging of the baby boomers in the United States, which means more and more share of the US population is going to be on Medicare. And so a larger share of the federal government's budget is being diverted to the payment of claims under federal healthcare programs, which naturally means that federal government enforcement follow the money as they always do. And so if you're operating in the healthcare space in the United States, the watchword really is caution and being aware of what your business is doing, who you're contracting with, how you're being perceived by the regulators, and taking care to be ahead of these trends rather than behind the eight ball. By the time the federal government perceives your company or your fact pattern as potentially criminal in nature, that's not a good position to be in. You want to prevent getting to that end of the spectrum by appropriate compliance measures, compliance programs, appropriate policies and procedures, all of the things that companies can do in a proactive way to keep yourself compliant and to keep yourself off of the radar screen of the criminal healthcare fraud enforcers.
Melissa, what are your final thoughts?
I definitely agree with Sarah that compliance should not be thrown in the garbage can. I think that you need to have good auditing and monitoring as a healthcare entity. Very often, whether something is criminal or civil is in the eye of the beholder, and it involves just the particular office or section of the Department of Justice that you're dealing with. And I think that, we see stuff prosecuted criminally in some parts of the country that could very easily just be a civil case in a different part of the country. And so there is very much a sense of people should not keep their foot off the gas pedal on compliance policies. I think additionally, we think that people should be very cognizant of their arrangements and, making sure that physician contracts are done appropriately. Even though ECRA has been sort of out there, is not prosecuted very much for clinical labs, it's still something that people should be concerned about who are in the clinical lab industry. And, we still think that healthcare fraud is going to be a major tool in DOJ's arsenal, and companies need to keep their eye on the ball here.
Thanks for that. And just for the benefit of our audience, ECRA is the Eliminating Kickbacks in Recovery Act, which was passed a few years back and focuses very much on the topic we raised earlier regarding opioid treatment and related lab services. Is that right, Melissa?
Yes, we see a lot of cases in the clinical lab space, and we do not think that that space is going to in any way be affected by the change in administration. The underlying theme of the government being concerned about overutilization of clinical lab services is definitely not going away.
So, Tom, I'll let you have the last word on this topic. How do we see this affecting the healthcare industry?
Sure. Thanks, Rich. I think two quick points I wanted to make. One, in my experience, when I would interview people or meet with people who were already in the office, it was really and several public reasons, the aggressive, enthusiastic, eager, intelligent people that really wanted to prosecute the white collar and healthcare fraud cases because they're so challenging in proving criminal intent. So I think as long as the department keeps those people, you're going to see healthcare fraud continue to be investigated and prosecuted. But balancing that with limited resources, I think you're going to see an emphasis on vulnerable populations, cases that could draw the most attention and have the biggest deterrent effect, as they can't prosecute everything. So I would think about being cognizant of clients who may have cases that touch patient harm or poor quality of care, those things could be right for the attention of the department.
Well, thank you. And thank you to each of you, Sarah, Melissa, and Tom, for taking the time to participate in today's discussion about criminal healthcare fraud enforcement under the Trump Justice Department 2.0. And thanks to all of our listeners. I'm your host, Richard Westling. And if you've liked what you've heard today, please don't forget to subscribe to Diagnosing Health Care, which is available wherever you get your podcasts. Thanks again for your time today.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.